Hey, everybody, and welcome to our urgent panel discussion about legal trouble and claims in InfoSec. And this all got started last week when there was what to some people was not a surprise, and others was. Others it was a surprise about SolarWinds and their head of security and what happened there. And in a second, we're going to jump into this, but just quick history here for us and our webinars. So a couple of years ago, we had some customers who said, "Hey, when things happen in the cybersecurity world, whatever they are, whether it's like a major international incident like Log4j or something like that, or there's something everybody's talking about." Like, can you guys talk about it? Can you explain to us like what's happening, what we need to know about it? And so we started doing what we've called urgent panel discussions around that. And then we invite guests to join us when we have great guests. And today we do have a great guest who I'll introduce in a second. And for those of you who've come to our panels before, you've seen him before. And so we look forward to doing this. There's a chat on the right. You can see people saying hello already. Let us know where you're joining from. We'd love to know. I am in downtown Seattle. If you don't like the chat, there's a little bell on the top with a line through it. You can unline through it if you like dings. You can put a line through it if you don't like dings. But the chat during these is usually pretty lively. Ask us questions as we go. Folks, converse with each other. I love interrupting the conversation to ask your questions from the chat. So go ahead and put one in. Also, everybody who registered will get an automatic recording from the system. We all know systems don't always work, and sometimes the recordings go to junk. So you can always email me, jake@criticalinsight.com, and I'll email you a YouTube link. We also put it on our YouTube channel. And everybody will get the slide deck. We'll send out an email probably tomorrow with the slide deck. Not many slides for the urgent panel webinars, but if folks want them, we send them out. Nothing super secret in here because we're talking about things that are in the news. Who are we? So Critical Insight defends critical infrastructure against cyber attack. We help organizations prepare for a cyber attack, help them detect a cyber attack with our Security Operations Center, and then respond decisively. Panelists today, Mike Borgia, would you introduce yourself?
Sure, yeah. Thanks for inviting me to our panel. I'm looking forward to it. So Mike Borgia, I'm a partner at Davis Wright Tremaine. We are a Seattle-based law firm. I'm based personally in Denver, and I lead the firm's information security and breach response practice group.
And personally, we've worked with Mike Borgia on a number of breaches. And he doesn't just talk well. Good dude. Mike Hamilton and Fred Langston both founded the company. Mike is our CISO, and he's the former CISO of the city of Seattle. Fred's our chief product officer and has spent many years consulting and in healthcare and public sector, and has spent many a time coaching CISOs in his career. My name is Jake Milstein. I run marketing for Critical Insight, and I host our events. And so welcome. So Mike Hamilton, why don't you tell everybody what happened here?
Okay, well, you started off by saying this all started last week or something like that. And no, it didn't. It started in the before times in 2020. And that is when, and I'm sure a lot of people remember this was a really big news story at the time, SolarWinds got compromised. And apparently it was Russian GRU type operatives, Fancy Bear, and they gained access to the code base. And what they were able to do was backdoor the code. And SolarWinds went and sent it all out to all their customers. And all of a sudden, all the customers had open invitation for the Russians to walk in and start stealing. And that's exactly what happened. So there was thousands of compromises from this. And it was really focused a lot on espionage. So it was intellectual property theft, but also government secrets. There was a lot of government emails stolen, things like that. So this was a really big deal. And, it wasn't very long after that SEC said, we're going to have a look around. And what they found was that, yes, in 10K filings that you periodically need to submit to the SEC if you're a publicly traded organization, where you talk about risk, specifically risk to investors and shareholders, right? Those communications are really meant for them. They're public, they're consumed by a lot of people, but they're really focused on investors and shareholders. They looked at the statements in those and they compared not only those, but public statements that have been made by Mr. Brown. Timothy Brown's the CISO there, on podcasts and in blogs and things like that. And they found that the public statements were not, and including those that were official and given to the SEC for distribution to shareholders, were not reflective of the actual controls that they found. And so they've taken the extraordinary step of suing the company for this and accusing the CISO of misleading investors and notably securities fraud. So, we had a little preliminary discussion before this, and I guess securities fraud is not that hard of a thing to charge someone with. I don't know if they're going to be able to prove that, if there was an actual financial benefit there or a benefit to the company for not losing stock value because of a filing that was more reflective of the actual control deficiencies in there. And it's interesting, too, that they found a lot of internal presentations by Mr. Brown to the board of directors and the C-suite regarding known risks and deficiencies. So this is all very muddy right now, but it's all fallen on Timothy Brown. And this has kind of happened before recently. So Joe Sullivan, CISO of Uber, covered up an incident and tried to convince everyone that it was a bug bounty that they had paid for someone finding vulnerabilities in Uber's technology systems, which was not the truth. And so he was charged and ultimately ended up, I think, being fined. He's got some probation. He didn't end up going to jail. So that was negligence. More than, well, that was actually not negligence. But what we have seen before is more accusations of negligence, and they're starting to really go up the food chain. So it is unusual for a CISO to be charged in this way, and very unusual for fraud to be part of this. So, the SEC is really trying to make a statement here. This is about enforcement, and there's going to be continued enforcement, and they are not messing around.
And hey, I want to get there are some great questions coming in the chat here, and I want to bring in Mike Borgia, especially when you were talking back here about securities fraud. Mike Borgia, what constitutes the fraud here?
Yeah, there's a number of provisions in various securities laws that you can call fraud provisions, but essentially, it's as simple as, with some variation, it's as simple as a material misstatement or omission that misleads investors, right? The idea being you want to go invest in a company, you're doing your research, you're looking up their statements, financials, and things like that. And there is some material information, material meaning it would, alter the decision-making or at least thought process of a reasonable investor. And so something is stated that's incorrect in a material sense, or it's omitted. So here, the idea, there's a couple things here I think it's important to stress. So when you think SolarWinds here in the SEC, you're probably going to think about the Sunburst attack, right? And it makes sense. But a lot of what's in this complaint is actually expressly, the SEC says this, independent of Sunburst. Right? They said a lot of this would have happened. There would have been fraud even if that attack had never occurred. And so there's kind of two overarching theories, if you will, about fraud here. One is, as Mike was saying, the CISO was doing what a lot of CISOs do, other security professionals do at big companies, out on blogs talking about security, the importance of security, describing the way the company handled its security. He was approving and looking at different public statements about the company's security that an investor might rely on. And those were allegedly materially misleading in a number of ways to talk about what those were. And then there's also a set of allegations related to material misstatements and omissions regarding Sunburst itself. So, and this is a little more classic in a way, a little more typical, under describing the attack, not disclosing in particular that they knew the extent of exploitation when they filed the 8K to disclose the attack. So things like that. So, but they both roll up to the same basic idea, which is investors want information to know, to make investment decisions. There's material misstatements in that information.
And, and then there's a big, so I'm just going back to the chat here. So, big questions that's come up in the chat is, why, and Mike Borgia, I'll start with you and then go to Fred and Mike Hamilton here. Why go after just the CISO here? Why are the charges not for other people? And, if there were audits, if there were anything, why start here?
Who you asking?
Well, it's a good question.
Start with Mike Borgia. Yeah. We'll start with the lawyer, and then we'll go.
It's a good question, and we have to maybe get into the heads of the people working on the case. But what's interesting is the SEC had previously issued Wells notices. Wells notice basically is a notice that says we're intending on bringing charges against you. Here's what we're intending to bring. And they'd issued Wells notice not only to the company and the CISO, but also to the CFO. And the CFO was not sued here. There were no charges against him. Now, maybe those will be brought later. That's not usually how the commission does it. They usually finish their investigation and bring it all together. I don't know. There's nothing that says they can't do it differently here, but that is interesting that they didn't bring it against the CFO. And I think that reminded a lot of people of Uber, right? Where you had, no question, numerous people at the company knew exactly what was going on, and they walked away, right? And there was a lot of frustration about that from security professionals. Why was the security professional the one that was left holding the stick, right? So I offer you two answers. The first, more cynical, the second, less so. And I don't know which is right, but they're possible, right? The more cynical version of this is, I think that it's just a scapegoating of security professionals. Perhaps, it's intentional. It's probably not intentional. It's probably more maybe a failure to appreciate the difficult situation that CISOs are in and the pressures they're under, not only to do their normal jobs, but also not mess with business operations and not slow the company down and lose money and things like that, right? So kind of a misimpression that the CISO is independent and off on his or her own and not subject to all these same pressures that the CFO and COO and whoever else is under as well. I do think, though, on the less cynical side, CISOs are in a unique place, right? Where they're titled CISO or not, they are chiefly responsible in, at least they can be, for informing the rest of the company about what the security risks really are. And I think one read of this is that although others knew, it was really up to the CISO. The kind of the buck stopped with the CISO to really make it clear what those risks were to the company, how realistic they were, and what they could mean for the company's operations. And you didn't do that. I guess it's another way of saying, when you're the face of something, the buck kind of stops with you. So
when you're the face of something, you're the face of something. Fred, how do you see that?
Well, I think it's going to come down to the trial, or if they get to trial, because they're going
to settle.
They'll probably settle long before that. But hopefully we find out that how much was communicated by the CISO up to the board members, to executives, if that information was freely shared. There will be a hue and cry about going after a singular person if he's telling them there are deficiencies in our security. And we believe that actually is what transpired in this case. So I think there is this element of we need to get through the adjudication process before we understand really why they charge this person, what they think, and there may be some follow-on. There could be a new approach where they're trying to use this person to find out more about what happened at the higher parts of the company and then leverage that for charges later. But I think the biggest change that should happen here is CISOs now would need to become a big C role at a company. If you are taking the hit for the entire stock value because of this potential misinformation, you need to be right next to the CFO and the CEO. Okay, this is that we're past that stage where we can continue on at that in that same fashion.
And Mike Hamilton, there's a note in the chat here that is very interesting. Seems like publicly disclosing the known control deficiencies would be the company and would put the company and their customers at greater risk.
And that is true.
Yeah, so it seems unsurprising that his external communication and public communications might differ. It puts CISOs in a tough spot. I mean, they're
well,
not.
Yes and no.
I mean, they're a security company.
No, well, SolarWinds not a security company. They are a network monitoring company. But when there's a difference between specific control vulnerabilities and statements of risk. So, it's nobody's going to say, well, we have a whole lot of unpatched, out of life, end of life Windows 2008 servers facing the internet. They're not going to say that, but they will say that, there are certain control deficiencies and improvements needed to further reduce risk in the company. So that's really a good point there, right? The lack of specificity that needs to be in those statements so that you don't paint a target on yourself. Maybe another thing that comes into question here, and my personal feeling is, and I'm actually a fan of, regulation when done right. I think there's some overreach going on here. And I think, we're going to end up getting some pushback on this. I'm going to go ahead and go to this next slide and, whoops.
One more.
Go to that slide right there. So, the possible effects here, right? These are just allegations. I think this is going up the food chain. It is extremely unlikely that the board of directors did not sign off on a final 10K statement, and they had been briefed. It's already out in the open that Mr. Brown was providing these briefings talking about, their identity and access management was completely inappropriate for the business they were in, and, their patching wasn't up to speed, and all of these things. And from reading between the lines there, it looked like, his organization, the CISO's organization, the security team was kind of under-resourced. So, right now, everybody's looking at this going, oh, this is all rolling downhill. It's going to land on the CISO. Fred made a good point. The CISO is not part of the C-suite. That is just not typical. And it needs to be typical. And there's also guidance that's come out of the SEC. If you read their, the latest rule on this whole 4-day mandatory reporting, well, that's just a little piece of what they said. This is about governance. This is about board representation and appropriate skills on the board to be able to advise the board appropriately. So right now, yeah, there's this chilling effect that's kind of going through the community. I think we're eventually going to find out that this goes farther up the food chain, because it is just not credible that this falls on the shoulders of a single person. And Fred might be right. This may be a way to get some more information about what was communicated so that the SEC can continue this. And again, what they've used before was negligence, right? And not fraud. And I think that, and you can see there, Gartner predicted 3 in 4 CEOs would be held personally liable. That's going to continue. Whether or not this case actually goes all the way and they're able to get a fraud conviction on here, securities fraud conviction, I think is really doubtful. I mean, if anything, they are going to settle. But before they do, they are going to do everything they can to find out where the fingerprints are here. So, and again, private sector is going to push back on this. And I think that another effect could be an increased use of third parties to do the kind of attestation, right, by an accredited organization, so that you're not, self-assessing and that's what goes in the 10K. It's actually audited controls and helping to devise a statement that doesn't give away everything but accurately reflects risk.
And so I want to go to Barry's comment in the chat here. Are we missing the core issue? Was the CISO really accountable to the software engineering and build processes? SolarWinds issue was the threat actors getting into the software build. In many companies, the CISO doesn't get into that space. That's the SVP of engineering. But Mike Borgia, what you were saying earlier is, if your name is on it, your name is on it, right? The issue here is what was said publicly, not what caused the vulnerabilities, right?
Well, yeah, and what was alleged is based on his knowledge, right? And
right.
Whether that's true, remember these are all allegations.
Right, all allegations.
Them, we're not saying they're true, right? And I wanted to clarify one thing too, just to make sure there was no confusion, especially for non-lawyers. This is a civil case, right? There's no jail being considered. This is money. All right, and then we were talking about the Sullivan case, which was criminal. So I wanted to be clear, even if we're talking about fraud and charges and things that sound criminal, this is a civil case. So keep that in mind. The Department of Justice would have to bring a criminal fraud, securities fraud case. Sometimes you'll see both at the same time, but this is a civil one. So it was about his knowledge, right? Now, I think in theory, if this had happened at the engineering level and he was never made aware of this, then you might have a disclosure problem. But I think it'd be very hard to allege securities fraud. I think where he gets in trouble, at least allegedly, is by both making a lot of statements about the company's security and having knowledge that the security is not actually that good. But keep in mind that a lot of these allegations are not tied back to Sunburst. So they don't have to prove that because they didn't follow the NIST cybersecurity framework, Sunburst happened, right? That's independent. They're alleging that he said, or was responsible for a statement. I don't think he actually said that, but I think he was responsible for a statement that the company followed the NIST cybersecurity framework and then knew they actually didn't do that. Right? That's the allegation. So there isn't necessarily causation back to Sunburst.
And Fred, how does that change the job or what should be in a CISO's purview? If let's just say that, Barry's comment is right here. We don't know that it is. Again, it's all alleged. We don't know that it's the SVP of engineering, but, vulnerabilities were caused there. The CISO may or may not have known. Does this mean that the CISO needs to get into the nitty gritty of everything that, is happening in engineering? Or is it, does this change what a CISO should be doing?
I'd assume that in policy, it is pretty well dictated exactly how engineering should be treating things that are critical flaws, or in this particular case, the implantation of a backdoor into their software. Now, they didn't find out, right, till after the fact. As far as I remember, it wasn't until it was in the wild and being taken advantage of that they went, holy cow, our software has been backdoored. So I don't think in this case in particular, we can look at their engineering department and say they were culpable, because I don't think they knew. But the policies as a company should be clear and should dictate that if you have an event or some sort of incident, it should follow the incident process. Should be well known, of course, to the CISO, because the CISO would receive a report, if not being intimately involved in the process. So I unless you have a disastrously poor communication within your infrastructure and no policy to guide you, that I guess this could happen, but it really should not happen that way. And I think the crux of this comes down to, what did the CISO know? What did that CISO communicate internally? And what were they responsible for that went into the 10K? As we all, remember, they're down the chain. They weren't the ones actually doing the speaking. The 10K was doing the speaking. And then we say that that particular set of information, those risks, were hidden by somebody. And I don't how they're saying it's the CISO when apparently everybody knew, is, to me, is the hard to understand part of this.
And Fred, I know you have some passion around this one. Paul's question, do you see this changing board composition to add cybersecurity experience?
if this doesn't, nothing will. As a group of CISOs, there should be a push to say we need to be leveled up. We're taking identical risk. We should be fully covered under directors and direct D&O insurance. And the representation on the board, this should be, but may not, right? It depends if they start trying to penalize other members of the C-suite. If that happens, I think you will see absolutely a change at the board level. If they go past them and just keep shooting at the easy target, they're not going to have, the government will not have the desired change they're trying to make.
And, Mike Hamilton, of everybody here, you're the one with the CISO title. You're CISO of the city of Seattle. Sorry, man. I'm sorry to break that news to you. But, and you put on your slide, likely uptake in D&O insurance. Yeah. How do you see this changing the CISO role? And also, how do you see this changing the CISO role for large companies and for smaller entities?
So good question. I'm just going to agree with what everybody else has said here. This is going to make the chief of information security a part of the C-suite. All right. When we were having our preliminary discussion on this the other day, and this always comes up in conversation, right? Who should the CISO report to? Not the CIO. Come on, right? This is a fiduciary responsibility, and reporting should probably be to the CFO, right? If not the CEO, because the SEC is dead serious about whether or not this case actually anything comes of this. They are dead serious about enforcement, and this is not the only way that they're doing it, right? There's negligence. There's, their sister agency, the Federal Trade Commission and the False Claims Act, and all this stuff that they can pull out. They're making people get with the program. And when I say that, it's less about make sure you have all these controls in place. We've been there, done that. We're tired of beating that dead horse. It's get your program in order, manage risk appropriately, have some kind of risk governance where you get executive fingerprints on risk decisions and the disposition of identified risks, right? Hey, here's this risk. We recommend that we mitigate this through the application of controls, and we're going to need some resources to do that. And that committee, which should have membership from the C-suite, if not the board of directors, is fine to say, no, we're going to accept that risk. But then everybody's fingerprints is on that. And if in the SEC rule, that's where they're talking about governance a lot more than mandatory reporting. And this governance issue is coming from Health and Human Services. There's a new governance section of the NIST framework. Everybody is going this way. So that's going to include larger organizations where the CISO is going to get elevated to a position that's more commensurate with, the pucker factor of the role. But in smaller organizations, they're going to have to, take up this governance issue as well. Because more of the guidance is also saying it's you and your third parties. So, right now, if you do business with the Department of Defense, you have an expectation of your third parties that they're meeting the same requirements you are. And this is just moving all the way down the food. It's cascading. So I think that if not in a smaller organization, elevating the information security officer to, a board level role, right? That's not going to happen. But making sure that there is a governance structure in place so that it's not just all falling to one person to make these decisions and then just having that denied. And then, you're just left with poorly resourced security and stuff's going to happen.
And Mike Borgia, how do you see this? when you're advising companies on, on who to put in charge of cybersecurity, is it a board level position? Is it reporting to somebody? How do you see it?
Yeah, it's a really interesting question. I don't think you can say categorically it must be a board level position. I think that's a good thing to do, but it depends on the company. Independence, I think, is the most important thing. So if you want to think about where the CISO role is going, I think it's actually really helpful to think about where the CFO role has gone, especially like in the run up to and after Enron and Sarbanes-Oxley. There's an interesting article I can put in the chat about this evolution of sort of, there was the 50s, 60s, 70s of like the bean counter CFO, like I do the reports, that's it. Then there's sort of the late 80s, early 90s, like swashbuckling, CFO of like, find us creative accounting solutions to pump this thing so we can sell the company. then there's Enron, and then there's kind of been something sort of in the middle. And Sarbanes-Oxley and other requirements have kind of forced some independence on CFOs as well. For example, having to sign certifications and things like that in your securities filings. Right? So I think we may see a similar evolution of, the CISO was, kind of just like another way to describe the IT team. And then, I think one thing way you could read SolarWinds is maybe of that sort of the more swashbuckly stage of, hey, we gotta make money on this security thing. We need to be out there. The CISO needs to be out there bragging about our security, promoting what we do, how great we are, really using that as a selling point. Well, I think companies are going to think a bit more about that when they read this complaint and all the things that are in there. And maybe what we'll have is settling on something more in the middle that is more of a kind of a quasi-independent role. Not the equivalent of a bean counter, right? We're well past that. But, again, I think focused on independence and, just having a lot of pressure to do the right thing. What I think is important, so I think there's a couple of things you have to think about wherever the CISO is. One, I agree. I don't know that you really can in most cases, or should in most cases. I'm not going to say you can never do this, but I think it is problematic, I'll put it that way, to have the CISO report to the CIO. Because I really do think, it's kind of like saying, let's have the general counsel report to the CFO. You're putting two people whose natural interests are not aligned kind of intentionally, and you're making one report to the other. And that just means that one is going to win out, right? There's a reason that general counsels are generally C-suite level positions, and they don't report to like someone in operations somewhere. Right? You saw that, you're like, this makes no sense. Your head lawyer reports to like someone who's 2 levels down the chain. This is terrible, right? A similar thing. I think also companies are going to need to really think about a lot of companies have been thinking a lot about ethics and have structures for this and need to think about a CISO in a similar way. So for example, certain kinds of complaints, whistleblowing and things like that, they've developed structures to handle those outside of normal reporting. There are companies under various different types of legal regimes that have to have some kind of independent reporting or audit or things like that. And I think we need to think about the CISO potentially as being sort of a quasi-independent role. The reason being because otherwise you're going to put your CISOs in an impossible situation of saying, you have these legal obligations to be forthright about the company's risks, but if you do that, you could lose your job. Right. So CISOs you're going to start expecting, if I'm being asked to have that level of candor and be prepared to go to the CEO, go to the board and say, this new product that you expect to make a lot of money, the security is terrible and we have major security risks. If you expect that level of candor, then that person is going to need a similar level of job protection and salary protection, or otherwise, what's the point? Crazy to take the job. So you're going to have to think about it that way.
Well, let's talk about, crazy to take the job. Fred, I know you advise a lot of folks here, 2 things. One, you have said before, organizations that don't have a named person in charge of security, whether it be, chief security officer, CISO, IT director, and head of security. One, you need a named head of security. That now seems more difficult, right? Why would somebody want that title, right? So that's one question. And then 2, what does compensation have to look like?
Yeah. So I think this fundamentally changes the role of the CISO. I think, as Mike alluded to, the key is to make sure that you have a risk acceptance process and a governing body that makes the decisions on what's accepted and what is not, and monitoring those risks over time. That should not end at a singular human being to make every risk-based decision on what's good or bad for the company. It should be made at a executive level in a collaborative fashion. So I think pushing to be at the same level as any other C, having them all involved in these risk-making decisions. It's not a hey, it's all on me thing. Frankly, that's how it should have been all along. And I think we're finally going to get to where we always should have been. Now, what does it mean for compensation? Well, you're going to negotiate some things you may not have negotiated before. The DNO, directors and officers insurance, you're going to want to make sure you're covered. You're going to want to make sure that your salary is commensurate with somebody that's taking the same kinds of risks. And usually the people that take these risks are CEOs, CFOs, COOs, right? So you should be looking for a salary commensurate with the other C-suite.
And, Mike Hamilton, do you think that do you think organizations will buy into that? Do you think organizations will say, okay, because of this, we will pay the CISO more, or the named person who's in charge of security?
I do, if they think that that will help insulate the rest of the C-suite from some of these allegations, and they can get back on, a good ethical track here, because things seem to have gone a little bit off the rails with all of these regulations coming out, and I think a lot of organizations not reacting well to some of this stuff. It's interesting that I used the word overreach before. And a recent thing that happened was the EPA tried to regulate water utilities to say, okay, when you do your sanitary survey, which you're already required to do by the EPA, now we want a cyber assessment. And EPA was sued by 3 states saying that, well, that was an unfunded mandate. Okay, well, as we are looking at the federal government doing everything it can to bring everybody into line to, reduce the risk for not only critical infrastructure, but the financial system, everything. I think there's going to be some pushback from the private sector on this, about this overreach. And this may be the case that does it. We're going to have to see. I note that the rulemaking process has abated somewhat since the EPA thing happened. And now we're going to see what happens in this court case, and we'll find out. To answer the other question more directly, I just think salaries are going to have to go up for this role. It's not fun, getting through audits and having to document your controls and produce artifacts that demonstrate that the control is in place and it's effective. And banks, financial institutions have to go through that so many times a year already. Now they're going to do that with publicly traded organizations writ large. And here we have a real hot seat forming. So I think, if somebody wants a CISO in that spot that is going to reflect well on the company and be careful about how statements are made, they're going to have to pay a lot of money for them.
And Mike Borgia, Hamilton talked there about overreach. Do you think, this is a civil case, if it doesn't get settled, it'll, get to a courtroom. Do you think, court will see this as overreach? Do you think, where do you think that sits?
Yeah, I think, I don't know. I think that a challenge that the defense have is that, I think the concept of securities fraud is pretty broad. And it's true that the laws are pretty broad in terms of saying you can't make material misstatements in connection with securities offerings, not security, but stocks and stuff, right? Securities. Mm-hmm. And so to some degree, it's inevitable, right? It is true that data security, cybersecurity, these things are material at some level to companies. And so if you misstate them, what could I see, for example? So no, I don't think that we'd see in a court, it could happen, but I don't think we would see a court sort of push back on the basic principles. Mm-hmm. They could reject some of the claims, right? You don't have enough evidence to support that, things like that. But you could see other challenges. I mean, if the administration changes and SEC composition changes, things like that, you could see new laws that change those standards. I think what's difficult here is there just hasn't been a lot of sympathy so far for corporate executives, including CISOs, on this. And individual liability is kind of popular thing to talk about, and it sort of feels good in theory, but it's very hard to get right in practice. And I think you struggle with that, right? I can understand why people see case after case where, a company does something. Let's assume it's bad. I'm not even talking about this case. So a company does something bad, company gets sued, company loses a lot of money, and the executives all, just leave, right? And like no worse for the wear. They just get a job at a different company, and that feels wrong. And sometimes it is wrong. But what's difficult is creating a regime where you're not just sweeping people in who are doing their jobs and maybe made a mistake, maybe overstepped what they should have said. Mm-hmm. Does that mean they should go to jail or, things like that? And then that's kind of what we're seeing now. So someone said earlier in the comments that it looks like the SEC is just trying to make an example. And that's totally right. I don't even think that's a controversial statement. I mean, the SEC, I think, is kind of clear about that. And you could say the same thing about the Sullivan case. I mean, how many CISOs have been in a situation where they've taken a really aggressive, perhaps not defensible, but maybe, kind of barely, let's call it barely defensible position about whether something is a data breach, right? With the advice of their counsel that's sitting there in the room. A lot, right? But they're not all getting prosecuted. And that's how a lot of this works, is you find a good case and you prosecute it civilly or criminally to make an example. And that's really unfortunate if you're the ones being made an example of, but that's true. The SEC doesn't bring that many cases, but they bring the ones they think are going to send a message. It's how they regulate. It's one of the main ways they do it.
Yeah, it's funny, speaking of the chat, Rick in the chat is talking about, companies having a designated felon. We think of this as like, who's the scapegoat for whatever happens? In my world, coming from communications, your PR person, whoever has to go stand in front of the cameras and talk about whatever bad thing happened in the company, is your dedicated, I don't want to say, they don't get arrested, but, your scapegoat, in this case. We're seeing that for security with the CISOs. Fred, I want to go back to, a different kinds of organizations here, because, in this case, we've been talking about an organization, SolarWinds, that has a product. And the question of, what are the vulnerabilities in that product? And what does that cause? But, when you look, and I'm looking at folks who are in the audience here, there are folks who are at hospitals, there are folks who are at cities and counties and utilities. They don't have a product per se. I mean, I guess you could think about a hospital as a product, but you don't really think of it that way. If you're not governed by the SEC and you're not, or that's not your oversight, and you're at one of these other kinds of organizations, how do you look at this differently then? Is it similar? You're not going to end up, the SEC is not going to come after you.
No, but for most, if you're in a regulated industry, there is some regulatory body that likely will come after you. And it's well spelled out in HIPAA, the levels of that they can go all the way to criminal if you're actually running some kind of fraudulent operation using people's healthcare IDs. You could go to jail. So there's plenty of tooth in some of these laws. But then again, if you're in an industry that is completely unregulated, if you will, and maybe you have PII, like California privacy laws, there is a right to bring suit on those if your data is breached. So there's always some club, I think, out there that you can be beaten with. So knowing which club that is and knowing how to avoid getting hit with it, I think is really what you need to do.
Good. So we have dedicated felons, and then dedicated clubs that you can be beat with. Mike Borgia, how would you advise? Let's say you were talking to the person who's head of security, not for something with a product, right, but like a hospital or a utility, city, that kind of thing. What how would you advise them based on this to do anything differently? Did I lose Mike Borgia?
I think Mike is.
Sorry, it looks like I'm having a little bit of connectivity. Can you hear me okay?
Yep. We got you now.
How about now?
Yep, we got you.
Okay. Laggy, but so obviously one question is, are you subject to SEC regulation? Right? And if you're not, then this doesn't directly apply to you. But there are some lessons from it. So let's assume, first of all, you are, but you don't have a product, right? The product is just a way to get at materiality here. So if you're SEC regulated, it's all about what's material to you. And I think one of the points the SEC was trying to make here was, Orion and security, all these things are material to this company because of what is the company is trusted to do, right? Maybe a different case if you manufacture physical goods and there's a security issue. I'm not saying that wouldn't be material, but it's not quite as part and parcel of what you do as when you manufacture software and distribute it to people, right? But other things could be material to you, right? So if you're a hospital, no, you don't have a product, but you're gonna have a very hard time arguing that data security is not material to what you do. And then if you have a security incident, unless you're still using paper, if you have a security incident, it takes down your systems. I mean, you're gonna have a hard time saying, if we can use our EMR, that's not material to us, right? So don't get focused on the product, focus on what the systems and operations affected mean for you. If you're not regulated by the SEC, again, you don't have to worry about a lot of this, but it is kind of shocking in a way to read through the complaint. And I think a lot of people will read that and say, this looks really familiar. We do this stuff all the time. We have blog posts and we talk about what we're doing here and there. And our CISO or others are out there talking about how important security is to us and things like that. I do think there is probably some overreach in the complaint. It feels like they're trying to make fraud cases out of statements like, we take security seriously. And I think it's very hard to prove no, you don't take it seriously. We're going to have an argument with that. But there are some we follow NIST. We have this requirement. You do or you don't, right? And so I think a lesson here for everyone is really think about that. And again, kind of going back to what I said about the CFO, I think many companies are going to rethink that and say, are we putting our CISO out there too much to be too salesy? Maybe if they're under this kind of scrutiny, they need to be more like the new CFO, kind of in the background, doing their thing, assessing risks, and not because all these statements are going to be used against us. I think it's important to point out too that this is not the only kind of legal area where this is happening. There's a lot of laws coming out, particularly in financial services, but not just in financial services, that are forcing more of a role for the CISO or head of the program, right? There's requirements to have one, to have a head, have a CISO, whatever they call it in the law. This person's got to be in charge. They've got to review things. They've got to report to the board or other governing body. So you're getting further away from a time where you could just say, oh, the head of security is someone who's fourth or whatever. You're just not going to, that's not going to be permissible under a lot of laws. Somewhat similarly, the CCPA, the California privacy law people talk about, there's proposed regulations that require an auditor. It's not the CISO, but they've got to have an auditor for their security. It's got to be independent. So it's kind of almost forcing you to have either an external auditor or internal audit. And then that audit's got to be signed by not just the auditor, but all the members of the board. Right? So we've got a lot of requirements that are forcing much more formality and independence on this function. And so companies are going to be forced into that regardless of. So
Mike Hamilton, I know, you think a lot about third parties. We are, Critical Insight is a third party to, some of these companies and provide that, provide that third party guidance. How do you think this changes companies' views of third parties, like to cities, counties, hospitals, anybody, with the SEC as their governing body now lean more into external folks to be the
I think so.
nation?
Yeah, because there's a difference between, again, your assessment, which is, many times aspirational, and that's kind of what's reflected in these filings, versus audited controls and the ability to craft a statement that doesn't disclose too much, but is accurate within the definition that the SEC uses for materiality. And judging that materiality is also something that the CISO is going to have to participate more in as well. I don't think outsourcing the information security officer is where they're going to go. Mid-sized organizations for sure, but in larger organizations, especially those that are publicly traded enterprises, use of as Michael says, internal audit even to check the work, and there's probably going to be more legal oversight in the filings as well. I think one of the things that we ought to be thinking about as well is, if you want to be the chief information security officer for an organization, what are the questions you should be asking on the way in to make sure that you are not, that person that everything is going to roll downhill to? Because, I haven't put a lot of thought into that, but I think that's kind of what's emerging out of our panel here today as well. Some of the things to consider if you're actually going to go for that job and you want to be protected, right?
Mm-hmm.
Are you going to, are you offering D&O insurance? And tell me what our risk governance looks like here. Tell me who the members are that can sign off on, the disposition of risk that we recommend, accept, avoid, mitigate, transfer. Because that would make me a lot more, I think, comfortable going into an organization knowing that there was this framework in there that didn't just rely on what I had to say.
Yep. Yeah, for sure. So as we get towards the end of the hour here, couple of things. Number one, at the end of all of these, my colleague Ginny puts a link in the chat. We love when you all take the survey. Was this good? Was this helpful? Do you have additional questions? And in there is a place if you want to chat with Mike Borgia or with me and Hamilton. You can let us know in there. We are going to do final thoughts here. So a couple more things. Another one is, as we think about this, these are the services that we provide. And I'm not going to get all salesy here, but what I am going to say is, one of the things that we provide under regulatory compliance is vCISOs. And somebody just asked a question about vCISOs that I'm going to challenge Fred here with in a second. But one of the things that we've done is for our MDR clients, as folks who use the SOC as a service, we're putting everybody on a platform called CyberSane, which is a GRC platform, so that folks can keep track of their risks, can keep track of all of this, and have a better view into their security posture. But Fred, we provide vCISO services. This is a good question here from Kenneth, who says, what does this do for the vCISO role?
Yeah. So, one thing to keep in mind is you are never going to be able to transfer that sort of liability, if you will, over to a contract or a part-time employee, right? They're not going to be signing a statement. They're not going to be putting together part of the 10K. They may be contributing or helping the team there contribute to that content, but they're not going to be the designated responsible party in this. So I don't believe you can put a vCISO at risk in that sense, which means somebody at that company is still going to have to take on responsibility for owning what that vCISO and the team that they're managing says to them. So I think that's a fundamental difference, but I think it does say to SMBs, you have to think about this the same way a larger company does, and it requires somebody who understands these broad risks to the company, not just I need to go fix that vulnerability, but we have a problem with our entire infrastructure, our wireless infrastructure, for example, and we need to go fix it.
Yeah. And so we're going to do final thoughts here. Mike Grant has a big question here, which is, when will some regulator or law firm come after the CISO for non-SEC company CISOs? I think we kind of got to that. But if somebody wants to hit that in their final thoughts, have at it. Email addresses on the screen are my email address. I can get you in touch with Mike Hamilton or Fred. If you want to get Mike Borgia, it's a good way to get him. And again, don't forget to take the survey. All right, guys, we're going to do final thoughts. We're going to start with Fred, then Mike Borgia, then Mike Hamilton. Fred, final thoughts.
So I certainly hope that this is an inflection point for where the CISO fits in an organization. I mean, it makes complete sense that you want to manage your major risk. The number one risk is a cyber risk today. Why are they not in the same position that your CFO or CEO? And so I think it's time the world matures and realizes this is a C-level position, full stop.
All right. Mike Borgia, final thoughts.
Oh, kind of by analogy, when an attorney is thinking about whether to be hired they want to get a job as a general counsel at a company, there's some things they have to ask. And one of the most important things is this going to be a company where my concerns are going to get listened to, or are they going to be discouraged and ignored, right? Are people going to work around me or through me, right? You have to think a lot about this. You have to think about, because you have to think about it for a particular reason, because, if the company gets sued and you've got a massive legal risk or a liability, and it turns out, well, yeah, I knew this was a thing, but I didn't want to say anything because my boss just tells me to shut up. The CEO or whatever is just like, I don't care. The smart thing to do for a lawyer in that case is to resign and say, I'm not going to do this. I'm putting myself at risk. CISOs are going to have to start thinking in similar ways that general counsels think about when they go and think about, like, I'm the person in charge here. And if this goes down, people are going to ask me what I knew and what I said. And so is this a place where I can say, I don't think the security on this is good. I think we've got a problem. We got to fix it. Then maybe the company says, yeah, we don't care. Okay, well, I did my job. I said the thing and I've made it clear. But if this is a place where either I'm going to be told not to say that, or if this is going to be, don't tell the CISO about this, okay? He'll just say no, go around him or her. Don't do that, right? Because you are going to be the one left holding the stick. And again, you're going to have to think about the same way a CFO or an attorney thinks about this job and the risks to themselves and the kind of environment they need. The security professionals need to start thinking a similar way.
All right, Mike Hamilton, final thoughts.
Okay, final thoughts are, I would say don't freak out about this. We should wait for discovery, and I'm sure that this story is going to change. Regardless, SolarWinds is going to settle. They're going to pay a fine, and they're going to put this behind them. I do believe that there could be an unintended consequence of class action by investors because of this. We're just going to have to find out. But we seem to be getting class action happy these days. And since the SEC raised the specter of this is securities fraud, there may be some investors that decide they're butthurt, and get together a set of plaintiffs for a class. We'll have to see.
All right, everybody. Well, thanks for joining us again. Those are our email addresses. The link is in the chat for the survey. We will send out a recording. You will get the slides. There weren't many slides, but you might want them. We'll send them out. And we look forward to hearing from you. Thanks, everybody. And on behalf of Fred and Mike Borgia, thanks, everybody, for joining us. Have a great day.
Yep. Thanks, everyone.
Thanks, everyone.
Thanks, Michael.